We're back on In Focus. We continue with our analysis on South Africa's genocidal intent case against Israel over the bombardment of Gaza. Wits University law professor Bonita Meyersfeld joins us now to discuss the significance of this case. Prof, good evening. Good to have you, and thank you very much for coming on this evening.
Good evening. Thank you, Tabo.
Let's talk firstly about what this court does. This court is the highest court in the United Nations, one would say, that settles disputes between states if those disputes arise. Did the South Africa presentation go far enough in establishing that indeed there is now an existence of a dispute between the two states?
Yes, I think that was one of the lower hurdles that the South African representation had to clear. So really the International Court of Justice will hear a matter where state parties to the United Nations Charter disagree on a point of law. And so demonstrating that there was a dispute between states was, as I say, probably one of the easiest points to prove before the court.
Yeah, and I mean, simply if you were to put it, what did they need to qualify? What did they need to meet to be able to get over that hurdle?
So the procedure, the International Court of Justice has its own statute of incorporation, and that statute lays down the various steps that a state party has to go through in order to bring a case to that court. And it's very interesting because even though it's a court that has authority over states, states have to consent to be subject to the court's jurisdiction in respect of each matter. So there are a number of steps that South Africa had to take to ensure that the court would hear the matter. It had to demonstrate that there was a live dispute and a dispute that warrants the oversight of the court, a dispute that is based in a conflict about the interpretation of international law and the responsibility of states, in this particular instance, Israel, under international law. So South Africa, by the time you actually heard the hearing today, that hurdle was already cleared. It had demonstrated that there was a principle of international law, in this case being the Genocide Convention, and that it, as an applicant state, had an obligation under the Genocide Convention to ensure the prevention of genocide, and this was its argument, and that the respondent, in this case Israel, had breached that obligation in that it was allegedly committing acts of genocide against the Palestinians in Gaza. So the crisp point, though, and what makes this case so unusual in many respects, is that it wasn't a case about a retrospective analysis of accountability or liability, but a prospective request. And that prospective request is what we call the provisional measures that the court imposes on Israel pending an outcome of the deliberation as to whether indeed there was an act of genocide.
And of course, a provisional measure, others would call it an interim measure if you like, has also a lower level of requirement in terms of you don't necessarily have to come to a final view that there is genocide, but you can pass with being able to demonstrate that some of the acts fall within the provision of the convention.
That's quite right. That is exactly right, and that's what Advocate Hassim made very clear in her brilliant opening comments, that really the purpose of this application was not to prove, if we were to use layperson's parlance or sort of the TV show parlance, we're not here to prove beyond a reasonable doubt that a crime of genocide was being committed, but rather that there's enough evidence, factual basis, to ask the court and justify asking the court for the imposition of provisional measures. It's a little bit like saying, look, let's wait a little bit to determine exactly what's happening. But just in case it is what's happening, please can we take these steps? And here's sufficient information to demonstrate that, as per South Africa's case and argument before the ICJ, Israel either has the intention to commit or has the intention and is committing the crime of genocide. So that was the nub of the argument before the court. And indeed, it is a lower threshold.
So what is likely to be the finding of this court? I mean, one has already said that Israel has committed genocide is not one of the findings that will come out of this court. Also, I suppose a dismissal of South Africa's case is also not what is going to be possible. So what realistically should we be looking out for?
I'd be very reluctant to hazard a guess as to what the outcome would be for a number of reasons. Firstly, because Israel hasn't yet presented its arguments, which it will do tomorrow, and we have a good sense of what it will probably say. But really, one can only intone a notion of an outcome once you heard both parties and seen the court's response to that. My assumption is that the court will steer very, very clear and give a very wide berth to any political considerations. So to the extent that there is a finding either against South Africa or in favor of South Africa, that finding, my view is that finding will be based very squarely on the legal principles presented by the South African legal team, and not on the larger political, moral, or international relations question here. It's not going to be about whether there is an historical wrong that's being committed, whether there's a justification for what's happened or not. I think there's going to be a very crisp, narrow decision based on the facts as presented by both parties and the question of whether those facts constitute a violation of the legal principles as contained in the Genocide Convention.
So if we look historically how this particular court would have ruled, for example, if the Gambia-Myanmar case would be an example there, the court just simply said abide by obligations under the Genocidal Convention. Would that make a difference?
So the court, of course, suffers the same fate as all international institutions, and that is it has very little, if any, mechanism for enforcement. So it can make any judgment, including a judgment that that Israel ceases its attacks in Gaza. But if there is non-compliance with that judgment, unlike in a national legal system where a person who's in breach or contempt of the court order can be arrested, there's no equivalent enforcement mechanism in international law. But that doesn't mean it's without its value. The statement of the court, either way, will have a number of important consequences, the first and possibly the most important being a basis for any future cases brought against individuals before the International Criminal Court, which of course is a different court, right, from the International Court of Justice. And the International Criminal Court will, in all likelihood, hear cases brought against individuals on either the side of Israel or Hamas regarding those individuals' alleged perpetration of violations of international criminal law. And if there's a case or a finding by the International Court of Justice that Israel has indeed violated the Genocide Convention, one can see that that would form quite a substantial or a substantial basis on which the judges of an International Criminal Court could hypothetically find an accused guilty of genocide.
And I suppose for that, also, I'm saying for that to happen, one of the measures then this particular court would need to give is one of the provisions South Africa is calling for, which is the preservation of evidence and ensuring that independent fact-finding missions are allowed to go into Gaza, and these would include investigators of the International Criminal Court.
Absolutely. Absolutely. And that is exactly why they're asking for this. And it's a fundamental component of the Genocide Convention as well. And the interpretation of the Genocide Convention is that fact-finding missions are able to access these situations. And really the rationale being, if a defendant state claims that there is no breach of an international obligation, in this case the obligation not to commit genocide, then why not let the fact-finding organizations have access to the areas of conflict? But it's going to have a long-term impact on the public narrative around the war, but it's also going to have a long-term, either way, I should add, either way. If there's a finding against Israel, or if there's a finding in favor of Israel, either way, that is going to have a very deep impact on a conflict that is quite unique and different from any other conflict. I mean, it's a conflict in which the whole world is invested. It's a conflict that is very different from Ukraine and Russia, not in terms of what's happening or how terrible it's happening, but just because factually, for some reason, people around the world are so divided on this. And in that sense, it's a very important moment for the International Court of Justice, because it will have a decisive effect on the way in which the global narrative around the conflict proceeds.
Yeah, I mean, also on that note, they're saying it would have a significant impact on the concept of right of self-defense. It could possibly set a new standard or even redefine what that means, should indeed the courts find in favor of Israel.
So certainly, I mean, I think there's no question that Israel had a right. Well, there certainly is a possible debate that Israel had a right to self-defense, but I don't think there's a very strong argument that it didn't. It has a right to self-defense. The question is whether the conduct and the nature of its aggression at the moment exceeds the ambit of legitimate acts of war, right? And even if one does go to war unlawfully, even if one is brought into a fray without legal justification, even then there is an obligation not to breach international law. But the nature, it would be very interesting indeed if the International Court of Justice came to the decision that Israel's conduct is legitimate self-defense and not a violation, or not in addition a violation of any of the international crimes, such as the crime of genocide or any of the other crimes, although those are not the crimes that have been put to the court in this case.
Prof, appreciate your time. Thank you very much for coming on in your analysis. Wits University Law Professor Bonita Meyersfeld there, joining us for that discussion.